Welcome back, everyone, for Session 2 of Day 1 of the 9th Asia-Pacific ADR Virtual Conference. Our second session invites an exciting discussion on the question of whether it is time for a new momentum in commercial arbitration. This session will be moderated by Ms. Se-Yoon Kim, partner at Kim & Chang. And our speakers are Ms. Narae Kim, Senior Legal Counsel at Daewoo Shipbuilding and Marine Engineering Company Limited, Mr. Jae-Sung Lee, Legal Officer of International Trade Law Division at UNCITRAL, Ms. Francesca Mazza, Secretary General of the German Arbitration Institute, DIS, Mr. Leng SC, Senior Counsel and Arbitrator at Ethics Court Chambers, Duxton, and last but not least, Mr. Robert Wachter, Co-Head of International Arbitration and Cross-Border Litigation at Lee & Co. That is all our speakers, so Moderator Ms. Kim, please take the floor.
Good afternoon, morning, and evening, wherever you are. It's very good to see you today. I'm honored to moderate the second session of the 9th Asia-Pacific ADR Conference. Our session is titled, A Time for a New Momentum in International Arbitrations. I myself was amazed at how the world has changed between January and now, and how the international arbitration has evolved during the past 9 months. In the beginning, we saw postponements and cancellations of hearings, everyone thinking that COVID will somehow go away in the next few months. We did not imagine at that time that even by the end of the year, where we are now, we would still not be able to travel freely and everyone would have moved to this new virtual world. I believe not just myself, but all of us were impressed by the speed at which we all have migrated to this world and how we all became tech savvy, whether you want it or not. The arbitration community has shown its real strength to make this happen, sharing experiences, implementing new measures, and actively taking part in helping everyone navigate these difficult times. As a result, we can proudly say that we are now feeling much more capable of dealing with the new normal. You have heard in the first session the amazing works that different arbitral institutions have been doing. Of course, we believe that is not the end. Rather, we believe now is the time for us to move even further forward. Now that we have adjusted to the new normal, the arbitration community is ready to think about how we can utilize all these changes to create a new momentum for the commercial arbitration. As just introduced by Sally, we have today a perfect panel to do the job, a stellar panel of different stakeholders within the community: arbitrator, counsel, client, UNCITRAL, and arbitral institution. They're going to share that and discuss what they have experienced, are experiencing, and what they can suggest as the new momentum for the commercial arbitration. Without further ado, let me invite Mr. Chan Lengson SC to share his perspective as an arbitrator. Lengson, the floor is yours.
Thank you very much, Se-Yoon. 안녕하세요. Good afternoon. You have heard, as Se-Yoon said, the previous panel, very distinguished panel, speak about arbitration in the age of COVID-19. They have actually covered a lot of ground that I am going to cover, but I will just try to give you more of a snapshot from the tribunal's perspective. And just to take stock a bit, well, it is true that prior to COVID-19, physical hearings were the norm. And even then, video conferencing was not unknown. In fact, the video testimony of witnesses, I would say it's not rare, but it is the exception. It can be permitted in circumstances that the tribunal considers necessary or convenient for any reasons, but parties would have to make an application for video testimony rather than physical testimony. In fact, you see this as an example in the IBA rules on taking of evidence under Article 8.1, where if one party wishes to make an application for a particular witness to appear by video conferencing, then you need to give reasons and the tribunal needs to balance a number of factors. Interestingly, even before COVID-19 struck, KCAB and a number of very, I would say, prescient experts came up with the sole protocol on video conferencing in international arbitration in 2018. So bear in mind, this was even before COVID-19 struck. So KCAB and the drafters, Mr. Kevin Kim, Mr. Tay Eugene, Mr. Yang Englong, and Ms. Lisa Min, came up with a very good draft on guidelines for video conferencing. And when COVID-19 struck, it became extremely useful for those that wanted to deal with video conferencing a lot more, to start looking at the guidelines and the ideas that contained in the documents. Since COVID-19, of course, nearly every pro institution has come up with guidelines. You have heard the distinguished panel before this going into them. You have, for example, the Hong Kong IEC guidelines for virtual hearings. ICC came up with them. CIARB's guidance note on remote dispute resolution proceedings. The latest one is from SIEC guide on taking your arbitration remotely, and that came out in August 2020. You have also heard Kevin Nash speak about the SIEC experience, so I'm not going to go too much into the institutional experience. I will just mention that the SIEC guide that came out in August is meant to be comprehensive and yet reader-friendly. It points out what parties and the tribunal should consider in relation to remote arbitration. It has 3 helpful appendices. One is choosing the remote hearing platform. 2 is the checklist for remote hearing procedural orders. And 3rd would be remote hearing etiquette. I will come back to the matters that the tribunal and parties need to consider very quickly. But before that, I want to touch on another development that Alexis has spoken about just now, and this is the Icc Rules, which will come into effect on 1st January 2021. It has updated the rules on a number of aspects, but as Alexis pointed out just now, the main one that deals with COVID-19 would be in the case management techniques in Appendix 4, where Article 26(1) expressly permits the tribunal to conduct hearing by either physical attendance or remotely by video conference. As Alexis pointed out before as well, the tribunal already had this power before this, and it's just a matter of making it more explicit. I will say the same goes for most arbitration institutions. Hearings are not limited to physical hearings. The tribunal has discretion and power to conduct a hearing in a manner that it considers most efficient and appropriate. I will not take up too much time now on all the institutional aspects, but I want to give some takeaways for a tribunal when considering an arbitration that might have to be run remotely. As Se-Yang mentioned as well, in the past, we had been talking about hearings that had to be conducted physically. And so when people couldn't travel in the early days of COVID-19, there were hearings that were postponed. But eventually, as we settle into the age of lockdown, we know that hearings cannot be adjourned indefinitely. So the inability to travel is no longer an excuse or a reason not to have hearings. But the tribunal must take into account other considerations, and that is the ability of parties to conduct a remote hearing so that the tribunal is fair to all parties. You have to consider where they are. Are they in a problematic location? And if they are, you have to give them time to work around that. But it's no longer an excuse for a party to just sit back and say, well, I can't travel, therefore I cannot have a hearing. Parties must make the effort and try to work around the problem. The second item that the tribunal should consider is, if you're going to have a remote hearing, what about the platform? There are a number of platforms that are available to host for hosting the meeting. And I personally, as an arbitrator, would not want to be the one to host the meeting, because I want to focus fully on the proceedings before me. I want to focus on what counsel is saying, what the witness is saying, and therefore I would suggest that parties find a service provider to host the platform. And this can be done under any of the major arbitral institutions or in any of the major seats of arbitration. You will find service providers willing to do that. And now that we're talking about online arbitration, in fact, you don't even have to find a service provider in your own backyard. You can find a service provider anywhere that would be most convenient to you. But that service provider must consider a number of matters, and that's why you need an experienced service provider. It must have IT personnel to troubleshoot and a backup plan in case the video drops. What is your backup? Would you have an audio backup if things come to that? You also have to make sure that the host takes care of issues of confidentiality and data security issues. The tribunal will have to consider what to do about the recording. Should it be made available? At the very least, of course, you would have transcripts and perhaps audio recording, but again, the tribunal has to decide whether that's going to be circulated. One thing that's quite important, if you are a team of lawyers operating remotely and you might not be in the same room with the team or with your clients, you may want to have virtual breakout rooms. Likewise, for a 3-member tribunal, it is quite important to have a virtual breakout room so that you can consult during the breaks. The third point that is quite important is document management. Nowadays, we are dealing more and more with electronic bundles. We still have parties and some tribunal wanting physical bundles. But I believe that eventually we will move towards using electronic bundles as the norm rather than physical bundles. I'll come back to the question of physical bundles in a while, but certainly you have to provide for that, and you need to have probably a service provider to manage the documents, unless the counsel wishes to take on the task. So it depends on how big your arbitration is and whether the counsel wants to have his or her attention divided. The important thing is, what about the witnesses? How are the witnesses going to have access to documents? Are they going to use electronic documents, or are they going to use physical bundles? If so, how are the physical bundles going to be made available to the witnesses? How are you going to ensure that they are unmarked? I think Matt Kinnear mentioned just now that in the past, there have been quite a lot of concerns about some of these issues. But from experience, we find that it's really not that insurmountable. Most of the time, I find that counsel have a degree of trust in each other, and they take a very sensible, practical approach to the question of witness testimony and access to documents. One word about electronic bundles. Counsel preparing the bundles must not be aware that the kind of tabs, physical tabs you have in physical bundles will not work when you just scan everything in PDF and send them to the tribunal. Without electronic tabs or hyperlinks, it's difficult to operate based on electronic bundles. So hyperlinks and bookmarks are quite important so that the particular document can be found quite quickly.
Thank you.
Yes. Sorry, am I out of time?
Yes, you are far
Right.
out the
I
time.
think I will stop here in that case.
Okay, thank you. I understand that Robert and Narae wants to comment on what Lengson just said. Robert, please.
Thanks, Youn, and thanks to the hosts and organizers for inviting me to be here today. Before I comment, the pandemic has been a great tragedy, and of course, our hearts go out to everybody who's been touched by people who have passed away or are suffering. But of course, for our business, it's been a fantastic thing in that it's really shaken us out of our complacency, and I think opened our eyes to a lot of things that we weren't aware of before. I think Lengson, is correct to point out that the pathway was there before. Where it was in the IBA rules and in institutional rules that we could have video conferencing, but at least for me, I've been a slow adopter for the technology, and for me that always meant the old hardware, where you would be in a video conference room, and you really had to go out of your way to prepare for that. And I think that new platforms like Zoom, like WebEx, like Teams have really fundamentally changed the dynamic. I remember late last year, I had a client that wanted to have a Zoom meeting, and I'd never heard of what Zoom was. And I was really reluctant and just wanted to have a conference call, but they were insistent, and we did it. And then after doing it, it was like, well, why haven't we been using this technology all along? And I think that in a lot of cases, this is going to change our perspective. Whereas before in the rules, it needed to be exceptional circumstances. There needed to be a justification for it. I think that in some cases that will really be called into question now. Lungson also talked about questioning whether there's really an ability to conduct the hearing and questioning where parties are. There was one case where I was an arbitrator before the pandemic, and there was a witness that was testifying from a detention facility in Indonesia where they had no video conference facility and where connection speeds were very slow. So I think in advanced countries with reliable connection speeds, I think that this transition might be easy. But in some places in the world where it's not going to be reliable, that's going to be an issue. And then he also Lungson commented on the desirability of virtual breakout rooms. But I guess on our team, we've still been suspicious of the technology or inadvertently not being able to use it properly. We've been very afraid to do that, afraid that we might not be in the room, or the microphone might be hot, or what we're saying might not be confidential. So we tend to be using chat functions or retreating into a conference room and making a traditional call to sort of confer. Maybe when we get more comfortable with virtual breakout rooms, we'll go that route. But those are my comments in reaction to Lungson's observations.
Yes, the host is very efficient in muting me all the time, so I cannot come in at the point I want to. Narae, you had some comments as well.
Yes, thank you. So using these new technologies to connect throughout the social distancing and staying at home, we also use these platforms to carry out the contract negotiations and also some without prejudice commercial settlement discussions. So it's very interesting that these new approaches has been adopted and introduced in the arbitration proceedings. And thank you to the players of arbitrations, and also many arbitration institutions has been very flexible and forthcoming to adjust and accommodate the restrictions under the pandemic situation. But still, I think we are facing a key question for either a new case or ongoing arbitration. You would choose to rely on these new approaches, or would you remain to use the conventional style of arbitration proceedings? From that perspective, it was very interesting and very helpful to hear the observations from the tribunal's perspective, as Leng mentioned, because one hand, it's very important to have accessible and easy use of arbitration from the business side. The other hand, the very important consideration for the arbitration cases that the parties are already on board would be that throughout these new approaches, whether the parties could present their cases and their pleadings toward the tribunal, and whether it could capture best advocacy and their practices to resolve the disputes. So I think this will give a lots of challenges and interesting tests to the players of arbitration.
Thank you, Narae. Now we have to hear from Robert about his perspectives as counsel. Robert?
Yeah, as I mentioned before, I think that one good thing about the pandemic is that it's really shaken us out of our complacency. Arbitration is not something that's supposed to be commoditized, right? What we all learned when we got into arbitration is that this is flexible, it's customizable, depending on the facts of the case. But I think that in a lot of cases, we got away from that. And as Kevin was mentioning earlier, I think that this is an opportunity to bring us back to what arbitration was supposed to be all about. I think that in many cases we've become, unfortunately, very inflexible. That we have a view of what the procedural timetable is supposed to look like. And that's the presumption of what every case is supposed to be, unless there's a strong case made to depart from that template. That template being, you have the introductory submissions, the request or notice of arbitration, and the answer response. Then you have 2 main submissions. Then you go through a document production phase. Then you have rebuttal submissions. Then you might have written openings. Then you might go to a hearing. Then you might have 1 or 2 rounds of post-closing submissions. So it might be that you end up stating the case 6 times in the normal case, which might be too much. I mean, that old format does have some good points, in the sense that from an arbitrator's perspective, I think a lot of arbitrators like this structure because you don't really need to focus on the case until the very end, until the hearing. Maybe you have to pay some attention, during the document production phase, but you don't really need to do a deep dive until the very end. And for the senior counsel, as the counsel, I think that that's also been a benefit. The idea that there's just one main event at the very end, but that's also the weakness of that structure, is that a lot of times you get to that main event and you find that the parties don't even agree on what the issues are. You go to the hearing and things come up at the hearing that you weren't expecting. And then you need some post-hearing briefs to address these new issues. And it becomes very inefficient in the long run. Another problem with that old structure is that I think that there's not enough attention devoted to arguing points of law, right? In the opening statement, we tend to be focused on the facts. We tend to be focused on issues of liability. Maybe 80% of the opening and the hearing is really on this question of liability, maybe 10% on damages, quantum, and maybe 10% everything else. And I think that a lot of times getting into the substantive law, there's not enough of a deep dive on that. And if you don't have experts on the law, it tends to be something that's just on the written submissions. And you don't really know if the tribunal understands the law. You don't really have an opportunity to deliberate with them on the governing law. And so I think that's one of the problems with that old structure. And I think that before the pandemic, it was really hard to get away from that. Like if you wanted an expedited proceeding, or you wanted to do something different, you sort of, as counsel, you needed to be out in front, because once the tribunal sends out the draft procedural order number 1, in a way, unless the parties both agree, you're kind of married to that. And it's very hard to convince the tribunal to do something very different from what they put out in the first draft, once that draft is on the table. So I'm hoping that as a result of the pandemic, we can fundamentally restructure the proceedings in a lot of cases if we get away from this idea that the main event is this one hearing where we all have to gather at the very end. So I'll throw out 3 quick ideas, three suggestions, just food for thought that may be appropriate, maybe not. First idea is to have an oral hearing after the main submissions and after the exchange of the Redfern schedules. This is similar to the idea of the Kaplan opening, which is a great idea, but in my experience was almost never done, where you give each side an opportunity to explain its case. And in the context of document production, you give each side an opportunity to explain to the tribunal, without making the tribunal go through the Redfern schedules on their own, what you need and why. You can explain it in simple terms. And each side can highlight those particular document production requests that are particularly important. A variation on this, you might give counsel an opportunity to ask questions of each other so that they have an opportunity to pin down the other side on what their argument is or is not. And that might be one way to narrow the issues earlier, rather than sometimes I think counsel are deliberately vague and you don't really know until the hearing what they're really arguing. Second idea is to have some limited document production at the very beginning, before the main submissions, based on the initial submissions, and then have one round of submissions after that, and then go directly to the hearing. Okay. You might have some rebuttal witness statements, but not a rebuttal submission. You flush everything out at the hearing, and maybe there's a need for some supplemental document production after that, which could be handled on a narrow basis. And then if the parties want to continue to argue, maybe you have 2 submissions after the hearing. But the idea that we get to a hearing faster, and if we want to have a lot of briefing, we do that, more of that after the hearing rather than before. Last idea is maybe to do the opening statements early, like a week before the cross-examination of the witnesses begins. Do that a week before, or have a separate session a week before, just to argue the legal points that are in dispute, and to maybe do a deep dive on the governing law. There's no need, I think, in a virtual hearing, to do oral openings and then go directly into the witness cross-examination. I think that it's good for the tribunal to sort of hear the openings, have a few days to think about this. It will help the tribunal prepare for the hearing better. And it also relieves the burden on the counsel, because they don't have to prepare for the oral opening and the cross-examination at the same time. Again, I mentioned before the reasons why I think that we need to carve out space to have a better discussion of the governing law than we've been doing in a lot of cases so far. So those are 3 suggestions. I think that it's really for counsel to push for these. I don't think that a lot of tribunals will suggest it. But I think that there are some creative arbitrators out there who might take the lead in suggesting these and other innovations. Thank you.
Thank you, Robert. Yeah, as I said, I was amazed by the speed at which we all moved to this new world. And I think that shows the real strength of the arbitration community. We were supposed to be flexible, and we showed that we are flexible. And as you said, it may be the arbitrators who may be a little reluctant in receiving that. So let's see what Leng has to say. Yeah, I know we are having some trouble because we get muted by the host. Host, can you please unmute Mr. Chan? Okay.
All right, I'm on, and that has taken up 30 seconds of my time.
Okay, so I'll now count it toward you.
Well, I'll try to speak faster. I certainly agree with Robert that we shouldn't be stuck to the old way of doing things. And the pandemic has actually forced us to get out of our comfort zone and start looking at things afresh. We had always been talking about trying to do things in arbitration, but now we have more of an impetus. One thing I would say that his 3 points are food for thought, but it will take 30 minutes to go through them, so I'm not going to try. One idea I would suggest, which I already used in arbitration, there seems to be something somewhere. One idea that I should have should say is that what the tribunal can do with parties is to have them provide as early as possible a preliminary list of issues, not wait until it's way down in the proceedings, and have it maybe as soon as the main bundle of submissions are completed. I mean, in common law, it's called pleadings. That's one idea. The other idea about doing things differently is something that Meg Kinnear had raised as well, and particularly in the age of a pandemic, that it'll be a loss if we go back to the old ways of doing things. Everything must be done physically, everybody must travel. And in this regard, Sean, if you allow me to say something, with regard to the Pledge for Greener Arbitrations, this was an initiative that was launched in November 2019. Lucy Greenwood wrote a very good article about it in CI Arps the Resolver. And basically, there was a study that was done on the environmental impact of arbitrations on trees and on emissions. And shockingly, they found that a medium-sized arbitration would require just under 20,000 trees to offset emissions. That's equivalent to 4 times the number of trees in Hyde Park and all the trees in Central Park. And when they look at the total caseload of arbitrations in all the major institutions for 2018, over 6,000 cases, it would have required approximately 120 million trees to offset the carbon footprint. And that's not to mention the emissions generated by air travel, which takes up 93% of emissions generated in a standard arbitration. So we certainly should look at ways to do things differently. Thank you.
Thank you. Yeah, it will be different, but it will be less fun. Maybe also because it took away all of our troubles. Now, Francesca, I know you have some comments to this.
Yes, thank you very much. And I'm delighted to be back in Seoul, even though it's just virtually. And I want to thank the organizers, and in particular KCAB, for inviting DIS to speak today. I see it as a sign of friendship between our institutions. Thank you very much. We are very grateful. I will touch upon some of the comments that were made in my statement later on delegalization. And so in the interest of time, I'll be very brief and maybe slightly provocative. I do think, of course, technology has an important role to fill moving forward. And we have been very lucky to have all of those platforms and tools that we can use. But I do think that it is very important to also find ways of upholding the human experience. I think it's working very well currently because we are building on a ground of exchange and human experience. I almost feel like I am in Seoul because I've been there before. So I do think that an important task for counsel arbitrators and arbitral institutions will be to find ways of human experience through this virtual environment. And I think that that is something that, because we all know and we all want to continue using the tools and learn from the experience we have made through the pandemic, I think that that's something that we need to keep in mind. For now, I would keep it to that. In the interest of time, I will comment on a few points later when I talk about delegalization. Thank you very much.
Thank you very much. Now we have to hear from the user, the client, what they think about how the arbitration is changing and what they would like us about, what they would like to see more to change. Narae, please.
Thank you, Moderator. I would like to start with thanking all of the efforts to have this session. Thank you for the organizing and hosting this session, and also the honorable speakers. It's a great pleasure to take part of the discussions of today's sessions. And further to the topic that today we're dealing with, how the COVID-19 situation has changed the arbitration proceedings and practices. I would like to discuss the trace of these changes from arbitration users' point of view. In particular, the topic I would like to talk would be, whether do you see that the COVID-19 situation itself has affected your client's choice and use of arbitration? And what are the subsequent changes which the players of arbitrations has adopted to accommodate the pandemic have any bearing on your client's consideration in choosing and pursuing arbitration as a forum of resolving the commercial disputes? As a starting point of this discussions from the perspective of user and the business side, the matter of cost and time would be one of the key issues in the majority of cases, among other various considerations and strategic factors that are taken into account to deal commercial disputes. So since the outbreak of COVID-19 and when WHO has declared pandemic in March this year, we could sense a change to the underlying factors that we consider, and also the answers to the questions that we consider when using arbitration. So for example, how much arbitration would it cost and how long would it take and how burdensome would it be? So these questions are a set of whether arbitration would be a cost and time-effective approach to resolve disputes as opposed to avoiding having an arbitration, or as opposed to court litigation or other ADRs. And I would say that the footprint of these changes on arbitrations made by COVID-19 could be discussed in 3 points. So the first point is the obvious one, and also as Leng has mentioned earlier, the globally, many business sectors are experiencing the economic downturn, and this inevitably would raise some new legal issues and also increase of the case numbers. But on the other hand, the economic downturn would require the business to be much keen to further reduce legal cost and become reluctant to decide whether or not to pursue legal disputes unless the specific dispute would help to terminate or cut down the cost. And rather, the business will be more likely to decide to seek early resolution and settlement of disputes. And I believe that this trend and the needs would be further driven by relatively small or medium-sized disputes, and considering the balance of cost and the result of the dispute. And the following second and third points that I would like to touch may have 2 opposing effects. The second point concerns the postponements and the immediate delay impact that we had experienced in the early part of this year. Especially as for the pending cases, we have experienced in deferring the hearing days to a later date when all of the travel restrictions and quarantine requirements would be lifted. So it is available to have physical in-person conventional style hearing. But as the pandemic remains, and although it depends on every country, this may potentially raise a question and a debate over whether we should wait until to have a physical hearing, or we should pursue to have virtual and remote hearings using these new technologies. And this may also lead to a debate over controversial issues of insisting to have physical in-person hearing would be viewed by the tribunal as a mere delay tactic, and avoiding to use available and easy solutions on an unreasonable ground. Or it could also ask the tribunals, a certain party requesting to have in-person hearing would be a fair procedural rights and request for their case to be heard by the tribunals. I think this will be a continued consideration that how we would advise our clients on this virtual hearing versus conventional style hearings. And the other stream is the reduced cost and the streamlined process of arbitration, that which has been actively discussed in the earlier session of today. So one of the key nature of our arbitration is the procedural flexibility, as opposed to other legal proceedings. And as we have discussed earlier, the tribunals, the councils, and also the institutions has been proactive to introduce the changes and adopt new approaches. So this change would be a positive indication to the users, implying that the use of arbitration, especially international arbitration between multinational parties, could expect that arbitration is be faster and is less expensive than it used to be. By way of having remote meetings and virtual hearings and serving the documents in an electrical manner rather than producing a lot of bundles and, as Leng also mentioned, sacrificing a lot of trees. And of course, using these remote technology tools rather than traveling and having face-to-face meetings and connect would reduce the cost, and it will enhance the accessibility. So I think these will boost the use of arbitration, being more accessible, efficient, and faster. And especially in terms of relatively small and medium-sized disputes, being more accessible to arbitration, and based on that, to achieve the resolution of the dispute is being more positive, and I think it gives you wider opportunities that the parties could deploy. So as each and every case is very different and of course should be treated differently, so I would not expect the implication of COVID-19 and the associated changes introduced to arbitration procedure and practice could not be only one side positive picture with a rosy future, but I think it's very worthy that we are discussing together to find a way forward and also to enhance and facilitate the use of arbitration. So I think the impact and the implication would be very versatile. So we look forward to finding the way forward in the arbitration committee in the context of commercial business dispute.
Thank you, Narae. And I'm sure UNCITRAL and DIS will want to have comments on this, what you just heard from the users of arbitration. Maybe Jae-sung first, please.
Thank you. Before I make my comment, I do have to make an institutional statement that UNCITRAL is very happy to be co-hosting this 9th Asia ADR virtual conference, which we have been organizing as a flagship event of our regional center based here in Incheon, which was established 9 years ago, and that's why it's the 9th ADR conference. So it coincides. Now, personally, I'm happy to be one of the 2 hybrid participants at this event. With Narae in the premises of the KCAB, but I also flew from Vienna last weekend, quarantined for 1 day, and then tested negative, and therefore was freed, and therefore now I'm at the premises. I have like 4 cameras here and 4 microphones, so I'm hoping that I'm looking at the right camera. Now, on the presentations by Narae, it was very interesting, and I think there was a lot of focus on the parties' expectations about cost and time of the changes that will bring. But a general question to you and other participants, and I think Leng also touched upon this in his introductory presentations, is the parties' perception about what fairness is and whether they would actually be able to present, whether they were given the reasonable opportunity to present its case. Now, would that change in this new normal? Would it be the same that if they lose the case, they simply think that it was not a fair case because of we are using remote means? So I think, how would it, I mean, I think that was what Leng was trying to hint at, but how would the tribunal make sure that the treaties feel that they're treated with equality? And what elements would the tribunal have to consider in order to ensure that equality is something that we have to bear in mind, especially from a party's perspective? Thank you.
Thank you. Francesca?
Yes, thank you very much. I would like to pick one point to comment upon, and that was the point you made about early conflict resolution. And the reason why I'm picking this one is because when we were revising our DIS arbitration rules back in 2017, the revision process that led to the 2018 DIS arbitration rules, that was actually the most important point, or the spirit of these rules, which are a set of rules that can be conveniently used by any international users, but a set of rules that has as distinctive features some tools, civil law based tools that can be integrated in arbitration proceedings. The spirit was exactly the early conflict resolution, and we were convinced when drafting these rules, and that was of course long before the pandemic, that the best way of saving time and cost is actually not incurring them. And therefore there is a strong emphasis also on settlement, on other, or permeability of the proceedings for other techniques, other ADR techniques, not MET-ARB though, but mediation windows through the arbitration proceedings. We have a dispute manager, which is an entirely new figure that doesn't exist in other set of rules at all. And we were really convinced that for users, the most important thing, or let's put it differently, for arbitral institutions, for arbitrators, and for counsel, a dispute is great because it's interesting, it's our daily work. And for a user, for a company, it's actually a distraction from the daily work. So we were looking for ways of emphasizing the importance of early conflict resolution. And I do think that the pandemic is an opportunity for everyone to focus on precisely that. And if I look at our cases, the cases that came in this year, or that we have been administering, we have seen an increase of cases during the pandemic compared to the previous years. At the beginning of the pandemic, even twice as many cases as the respective months in the years before. But we also see an increase in settlements. So that is quite interesting. I do think that for users, they will more strongly maybe focus on settlements, and I do hope that the in-house counsel will take a more active role also in shaping the arbitrations with their outside counsel. Thank you very much.
Thank you. I think both of you are right that if we do not change during the ages of the pandemic, the users may change their attitude about arbitration. And I think that's why the discussion today is very important. Narae, do you want to answer the question posed by Jae-sung about whether the parties will have the issue of fairness if the arbitration is moved faster and through virtual setting?
Thank you. I think that's one of the difficult questions, and the questions also we are facing for the current cases when we discuss with our internal clients, especially for the cases of so-called high-profile disputes, such as construction disputes, which involves many factual witnesses and technical experts. And definitely those cases will involve a large set of counsels. Having these type of disputes, we still struggle the question of whether we should proceed the proceedings and push forward through having the virtual hearing, or whether we should reconsider and be more prudent, that this could be difficult and it would raise the fairness throughout the procedural aspects. And so I think from that perspective, we had the questions whether the advocacy to the tribunal through these new technologies will be effective to the party or not.
Okay, thank you. Jae-sung, I think you have comments to make on the discussions in the UNCITRAL regarding the need for change of law and also use of technology.
Thank you. I'm not sure if I picked up. Yeah, okay. I feel like I'm in a studio. And now, as we're discussing the new momentum, and as I represent a norm-making body under the auspices of the United Nations General Assembly, I would like to touch upon the question of whether we need new rules or new laws to adapt to the new environment and the changes. Now, the first session and the panelists before me actually touched upon and examined what has changed and whether they will actually stay. And in the same vein, the UNCITRAL Commission held a virtual panel in July of this year to kind of look at the short and long-term impact of COVID-19, where many of the arbitral institutions that are here today share their experiences. Now, I function as the Secretary of Working Group 2 on dispute settlement of UNCITRAL, which is currently preparing expedited arbitration provisions. Now, rules that would accompany the UNCITRAL arbitration rules, mostly like as an appendix, which aim to simplify and streamline the arbitration process to save cost and time, as Narae has mentioned, for resolving disputes. Now, even before COVID-19, there was a discussion about whether the use of technology in the arbitration process, but mainly for holding case management conferences, for holding hearings, and for taking evidence, including witness statements, should be highlighted in the context of expedited arbitration. Now, one view was that such aspects were key to expedited arbitration and should be expressly mentioned as a rule. Now, another view was that the arbitral tribunal already had that discretion under Article 17.1 of the UNCITRAL arbitration rules, which state that the arbitral tribunal may conduct the arbitrations in the manner it considers appropriate, provided that the parties are treated with equality and given a reasonable opportunity to present its case. Now, with all of that providing a fair and efficient resolution of the dispute itself. Now, Article 28 of the UNCITRAL arbitration rules, also on hearings, mentions that the arbitral tribunal may direct that witnesses be examined through video conferences. So there are rules. And I think Lengson and a number of other speakers mentioned guidelines as well, and Lengson mentioned the ICC rules as a new rule. So the question that we have is, what do we need? Do we need new rules to actually adapt and accommodate the new momentum? Now, the working group 2 met in September, also for the first time in hybrid fashion, with 5 delegates in the room and 200 delegates participating online. Now, you have interpretation today in 2 languages, but as an official UN meeting with interpretations into 6 official languages, it was quite a difficult task for us to manage the meeting. Now, we could only meet for 4 hours a day. I think we mentioned that because there's a limited time frame that people can meet. Midday in Vienna to allow for participation from the Far East, from Tokyo, and for the Far East who were participating from Los Angeles. Now, as Meg mentioned, the most echoed words during the session was, can you hear me and can you see me? Now, yes, we could, but in certain cases, we had faced technical difficulties and therefore we had to use the chat functions to actually go through the discussions, to do the negotiations. Now, in any case, the working group agreed after discussions that the expedited arbitration provisions should include a general rule that would address the possibility of the arbitral tribunal to utilize different means of communications during the proceedings and to make use of virtual and remote hearings. So that was the decision that was reached. But now one caution that the working group expressed was that the inclusion of such a rule in the expedited arbitration provisions should not be interpreted to imply that the use of technology and remote hearings was not possible in non-expedited arbitration contexts. So I think that was the cautious approach that the working group took. I think the main rationale for the working group's decisions to include such a rule was that it would not only recommend to the tribunals to make use of these technologies, but empower them with the explicit discretions to make use of technology and use remote hearings. as a way to expedite the process as we are currently preparing the expedited arbitration provisions. Now, such a rule would address possible due process concerns, as some has raised, that could arise from such use. Now, but most of you may also be aware of a recent decision from the Austrian Supreme Court in Vienna, where I came from, in which a party challenged all the tribunal members, all three of them, for their decision to hold hearings remotely in light of the COVID-19 pandemic. So just one fact that caused the challenge was that they decided to hold the hearings at 3 p.m. in Vienna, which was 6 a.m. for the respondents' counsel and the witnesses who were located in Los Angeles. So this was one of the bases for their challenge. And the Austrian court rejected the challenge and confirmed the arbitral tribunals had the power to hold remote hearings and rejected any of the due process concerns. Now, that decision is a landmark one, but the preparation of a specific rule on the use of technology and remote hearings could avoid such disputes happening in the future. So particularly because the parties would have agreed to that provision, because if they have agreed to the expedited arbitration provisions, they would have agreed to that rule, and it would actually empower the tribunals to hold virtual hearings and make use of technologies to expedite the process. So the only message that I can say now is to stay tuned for the developments at UNCITRAL, because we hope to have the expedited arbitration provisions adopted in summer of next year. Now, as a representative of UNCITRAL, and because I think one of the speakers touched upon retention of data and preservation of data as well, I must also emphasize that UNCITRAL text on e-commerce, which enables the use of electronic documents and electronic signature in the context of to meet the writing requirements and signature requirements in other laws, have to be considered. Now, I say this because not all rules to respond to the COVID-19 and the new developments, including the use of technology, need not be found in the arbitration rules or in the arbitration law. They need to be actually coordinated with other laws that actually govern electronic transactions. And I think we have to bear this in mind as we think about whether we need any new rules to be prepared for any new developments in the arbitrations. So with that, I thank you. And I think I met the 7-minute deadline that you had imposed because I was looking at my clock and I'm 4 seconds over. Thank you.
Yes, I was surprised that actually you are the first person to meet the deadline, and with so much information, you were doing it in a really great manner. And the biggest surprise I have is actually you managed to make me understand what you were saying so fast. So that's what we call great delivery. Now, I'm sure Leng will want to add something to this.
Right. Well, thank you, Se-Young, and thank you, Jason, for that very important snapshot of the work of UNCITRAL on expedited procedure. I just want to point out that the work of Jason and the UNCITRAL Secretariat is particularly difficult because if you look at expedited procedure as implemented by arbitration institutions like SIAC and ICC, there is an existing secretariat, there's an existing court of arbitration that has power actually to make certain decisions that will enable the arbitration to go along a lot faster. What Jason mentioned about remote hearing and so on, as he pointed out, is a case management power of a tribunal that already exists. And having an expedited procedure just merely emphasizes that the tribunal is supposed to move more robustly and parties are supposed to move more robustly as well and quicker. But there are other aspects of expedited procedure, like having one arbitrator instead of 3, and powers of the arbitration tribunal under expedited procedure to decide matters based on documents that are rather more complex and may require specific rules as well as the intervention of the secretariat as to when you decide on expedited procedure, notwithstanding that one party may want to do otherwise. So these are things that are made more complicated by the fact that an UNCITRAL arbitration is not an administered arbitration. And I have to take my hat off to the work that has been done by the secretariat, like Jason, to overcome all these rather difficult conceptual issues.
Thank you. Francesca from, sorry, Robert from Counsel's perspective.
Yeah, one thing that I've always appreciated about the UNCITRAL rules is that they are simple and lean. In an era where a lot of arbitral institutions feel like they need to innovate and to, publish a new set of rules every 3 years or 5 years, I really, it seems to me like UNCITRAL has this more long-term philosophy that our rules can work for decades because we have what's really necessary here. I think this innovation, though, talking about the use of technology, I think it is appropriate for a rule if it is limited to expedited arbitrations. I would be very reluctant to have such a rule covering general arbitrations, because I think there are cases where there shouldn't be a presumption, and we should be very careful not to lean towards having a virtual hearing for certain types of cases. And I say that because I know that counsel can be very comfortable and confident that we've done a great job and have presented the case in a virtual hearing. I think that arbitrators can feel very confident that they are able to evaluate the witnesses and the testimony. I think that witnesses might feel confident that they were able to get their testimony across. But I have heard from clients that clients aren't so confident in particularly important cases. And it's clients that want to have an opportunity to appear before a tribunal. I think in a lot of these expedited cases, there might not, probably in most, there's not a need for an in-person hearing, or maybe even a hearing at all. I think there are a lot of cases that are simple cases of contract interpretation and should be decided expeditiously and through technology. And so I think that the idea of introducing that through a new rule just covering expedited procedures is a good thing, but not in the general rules.
How about the law on new technologies? What's your take about that?
I have the same reservations for any change in the law. I think that I think that more arbitrations could be handled in a more expeditious, simplified manner. But the bigger cases, the complicated cases, we shouldn't rush into that.
Yeah, thank you. Now, last but not the least, Francesca, let us, give us your story about the legalization of arbitration and distinct features of DIS.
Thank you very much. I know that if I say that international arbitration is a unique process, I'm preaching to the convinced in this forum. Through a global network of highly skilled and trained and internationally open-minded and high-performing individuals, international arbitration creates a flexible system for dispute resolution, and a system that creates options for companies which need to resolve their disputes, maybe now more than ever. We all know the story that over the years, arbitration has become more costly and proceedings take longer. Probably that is because arbitration, we have observed a tendency of alternative dispute resolution to mimic formal judicial processes over the time. Now, is this pandemic an opportunity for delegalization of the international arbitration process? Before I answer this question, I would like to pause and ask whether it is actually the right question to ask in the first place. The way the question is framed, it presupposes that delegalization is desirable, something we would like to achieve, and I myself believe it is. For me, every arbitration is a microcosm of procedural flexibility, and legalization is a tendency to the opposite, or maybe to put it more mildly, legalization is the process of encrusting the flexibility. I have over the years observed two subsets of that legalization of international arbitration. The first is imitation. Arbitration is becoming more and more like litigation. The second is harmonization. International arbitration is becoming more and more a melting pot of civil law and common law inspired techniques, using the flexibility that the process offers, not to make it lighter, but rather to combine both worlds, and thereby creating a process that arguably is even heavier than the respective litigation process in each of the jurisdictions would be. Now, in my view, the answers to those two tendencies must be creativity instead of mimic and imitation. And we've heard speakers before talking about creative ideas of how we can use the pandemic situation to actually come up with new ways of doing things, not only in the technological sense of organizing an arbitration. And the second answer, in my view, is integration instead of harmonization. Now, having said that, back to the initial question, do I see an opportunity? Yes, I do. We are experiencing a truly unique time. I would even go as far as saying a truly unique time in human history. We have a global phenomenon that nearly the entire planet is dealing with simultaneously. It feels a little bit like a shared experience of war, although I myself have been lucky enough not to experience war, but it feels like what I imagine a war situation could be, or any other form of crisis. But actually, those situations also bring out the best in people. We are forced to put aside our otherwise sometimes petty disagreements and work together for the common good. And there is really, I think, a broader sense to this situation, to this pandemic, that we are, in fact, all in this together. And I do think that crisis has always presented opportunities for innovation and is a fertile ground for those who are fearless enough to look past the obvious obstacles and just find a way of going forward. We are now in flux, a period of dramatic shifts that are taking place around all of us. We don't know yet what will become the new norm and what will fade away. And we are trying to look for patterns, for trends that help us determine what looks like a leg of a foundation for the future and what is just merely a way of dealing with the situation as it is, transitorily. Now, as we navigate this new reality, I do think that there is going to be a constant battle, I've mentioned that before, to balance our digital and analog worlds, or human worlds. It is important to look at technology to help us, but I also think that it's very important to never abandon the human interaction. There will be real practical changes that will help us to bridge this divide, and we need to be creative. For now, I don't know what those bridges will be, but our goal should be to create environments that inspire us to do a better job every day and to improve arbitration every day to the benefits of the users who need our services more than ever. And I think that integration is key to this. We need to focus everyone on what we are best at and preserve our traditions in dispute resolution. At DIS, we have provided a set of rules that, as I said before, works well for the international community, but puts forward German traditions of early conflict resolution and arbitration. We have presented our rules to the Korean community last year, and I truly hope that we can come back soon to Seoul to continue our dialogue. If I had to pick one single distinctive feature of the DIS arbitration rules that helps us achieving this integration, that would be the way we have shaped the case management conference. In Article 27 of the DIS arbitration rules, parties are asked to attend the conference alongside their outside counsel. The tribunal and the parties are required to discuss a catalogue of measures to increase efficiency and shape their process. but they're not required to adopt any of those measures. It's just that if they don't, well, then the proceedings will last longer and be more costly. It's a choice. And that case management conference and that catalog can also be used to shape the arbitration and to bring in these creative ideas at a very early stage of the arbitration. So the case management conference in the DS arbitration is really designed as a moment to pause and think twice. Think twice about how to best use the procedural flexibility for the given arbitration. We did not design a one-size-fits-all super efficient procedure. Rather, we designed a process for the tribunal and the parties to design the perfect procedure for the arbitration therein. And I do think that that's an opportunity for tribunals and parties as well in the pandemic situation. And creativity is the key in designing the process. And I repeat what I've said before, every arbitration is a microcosm of procedural flexibility, and we should be using that flexibility for best serving the needs of our users. South Korea and Germany share a common tradition, actually, and I see a common legal tradition, and I see a great opportunity to make our belief in a more consensual approach to arbitration better known to the world, and for the entire world to take us as a source of inspiration. And finally, last but not least, I see a great opportunity in this pandemic for attracting and retaining talent to our field. I cannot emphasize enough the importance of the rich and diverse ecosystems of individuals I've mentioned at the very beginning that actually keeps international arbitration going. The flexibility of our system provides or can serve as a magnet actually for international talent during this pandemic. How to persuade the best and brightest, especially younger practitioners from across the world, that international arbitration is an attractive place to build their careers. I am convinced that this pandemic will help us in providing answers for future generations. Last time I spoke at the ADR festival, the Secretary General of KCAB asked me to give a glance in the crystal ball of the future of international arbitration. If Sue asked me to do this again and tell you today where I think we will be standing after the pandemic, my answer would be less creative than last time. To be frank, I have no idea. I have no idea when that post-pandemic moment will be, and I have no idea where we'll be standing. But what I do know for sure is we should hit the post-pandemic ground running. And for that, we need to stand together. We need to exchange our ideas for arbitration to continue delivering its best. Thank you.
Thank you very much, Francesca. Jae-sung, from UNCITRAL's perspective, any comments?
Thank you. I think Francesca did mention about delegalizations, but I think we also have to think about the full menu of options for dispute settlement. We are probably tired of all these webinars on the, what's happening in the what COVID-19 has changed arbitrations, but we do have to look at other dispute resolution options. With the entry into force of the Singapore Convention on Mediations, which now functions as the New York Convention, like the Singapore Convention, like the New York Convention for settlement agreements that are reached through mediations, there is the possibility of actually to mediate a dispute. Now, how mediation is to be done in a COVID-19 pandemic situations, there hasn't been done many webinars or seminars on that. Of course, we have to look at all the confidentiality issues that would arise in the mediations, because all of the recordings can be available to the other party, especially if it's not, shared with the other party. So I think in considering delegalizations, we also may wish to think about de-arbitration in the COVID-19 pandemic. And of course, in order to have a very amicable settlement, you need kind of an in-person contact, whereas that's not going to be possible in a COVID-19 situations with travel restrictions. So I think we should think about other options generally of the menus for resolving disputes in this very exceptional circumstance. Thank you.
Thank you. And last comment from Narae, the user again.
Thank you. Thank you, Francesca. It was very helpful to have your insights on the arbitration and especially in the concept of delegalization. I understand that Francesca has made emphasis on the flexibility and also the creativity of carrying out the arbitration. As myself working as an in-house counsel and closely discussing with our project teams and the commercial people in the company, they often surprise that when we explain the proceedings of arbitrations, that the details varies case by case, and even there is certain rules enforced by the institutions, or even if it's an ad hoc arbitration using UNCITRAL rules or LMA arbitration rules, that there is a basic norm, but implementing and carrying out each and every steps of the arbitration is not set out in the express terms of the rules. And I think that's the beauty of the arbitration, as Francesca has emphasized. So for each and every cases which are very different and unique and has various dimensions, we could use the forum to resolve the disputes, and it's very flexible. Once you get on board arbitration, and if you find opportunity to engage into commercial settlement discussions, you could carry on the arbitrations in parallel, concurrently, or you could agree to stay and suspend the proceedings, and you could put your efforts and the time focusing on the commercial settlements. And if that works, then there's the close of the case. But if that does not work, you can carry on the proceedings, and then even thereafter, you still have the chances open to seek the various routes to conclude the resolution of the discussions. Thank you.
Thank you. Now, I wanted to give you one minute each to go give your one last comments, but we ran out of time, so I think I won't be able to give you that opportunity. To wrap up what I understood as my speakers' presentations tried to deliver, I think in one word, maybe in the crystal ball approach, maybe after the pandemic, we will be able to, instead of saying how we are doing virtual hearings and all of that, how we have adjusted to the pandemic, how we have adjusted to the new normal, after pandemic, we will be able to share information and experience about how creative and diverse and fit for purpose each arbitration has become. I hope that's where we are heading to through this pandemic, and that's the new momentum we want to pursue. Thank you, everyone. Thank you for your thoughts, and I wish I could give a big round of applause through the virtual setting. Thank you.
Ladies and gentlemen, we've now come to an end to day one of our ADR conference. We would like to thank all participants for your cooperation and support. Today has seen many wonderful discussions within our ADR community. We also apologize once more for the technical glitches, which we will make sure to have fixed for tomorrow. And we also thank you for your patience and understanding. We promise you there will be further interesting topics tomorrow, so please join us again for session 3 and 4 at 4 p.m. Korean Standard Time and 8 a.m. Central European Time. Once again, thank you all for joining us today for this year's conference. Thank you and goodbye.